to all the participants for this wonderful session. Uh, the topic of today's discussion is absolutely relevant from a Bangalore industry, technology industry perspective. Uh, though Mr. N. Venkatram and Mr. S. Ganesh will take you through the rulings, the nuances, and the issues behind it, but this issue has been catching the attention of department for quite some time. It's almost since 2000. The first order was passed in Bangalore somewhere in 2000 when the software was considered as a royalty and subject to tax. And at that point of time, one additional commissioner was there called me, PVS, and Bala and Sunil knows him called name. The author of this order was called one Mr. Rajkumar Lachiramka, who was the first person to pass the order in Bangalore, considering the software as a royalty. And then we have been arguing this matter for ages. And then there is some rulings came up in Bangalore, and later on, the Samsung ruling and other rulings took a different position. AIR in Danfoss has took a different position, and Delhi and Mumbai had a different positions. There's a conflicting judgments are coming up. And interestingly, there is an emerging issue task force was constituted by the government somewhere in 2004 or 5. In the Supreme Court ruling, there's an Indian High Power Committee report was showcased that the software is a royalty, but I do not know why. Of course, EATF report did not become public at that point of time. PV Srinivasan, who is there right now, who is a chief mentor of PVS Advisors, was part of the emerging issue task force. And EATF was constituted by the then government to go into the nuances of all the international tax. And the first issue was taken up by the EATF was on software. I think not for the second issue, memory is PVS can correct my memory. The second issue was taken by the EFTF was on software, whether it is a royalty. I was part of the team that made a presentation before the EATF. And EATF, my informal sources says that EATF concluded that software is not a royalty and shrink wrap license is not a royalty. And later on, I do not know whether the government did not, EATF did not sue the government, and the EATF was disbanded completely, and EATF was not functioning after that. And there are enough, and when Indian High Power Committee gave a report on software as a royalty, and I remember it was in one of the conferences in Bombay, where a parallel committee was constituted by the experts from Nishit Desai Associates and various team members, and they came with a parallel report that why software is not a royalty. And later on, there's a OECD, before the OECD, and later on, there's a OECD comments also came why software is not a royalty. And there are some of the international rulings also came why software is not a royalty. There are a lot of judicial precedent, judicial practices are going on. And before requesting Venkatram and Mr. Ganesh to take the subject, my way of looking at it is that purchasing of a software is like purchasing a book. What is there in the book, it is in the CD. You can't, for example, I am buying a ITR report. Instead of ITR report, I am buying a ITR online CD. If you say ITR online is a royalty, therefore you need to pay tax, it is ridiculous. That's my one-liner I would like to put it across. And unfortunately, the department made an amendment to section 916 with retrospective effect. In fact, I was jokingly telling PVS at that point of time, 1976, there's no software in India itself. There's only hardware. That's not even a hardware. Only on IIT had an old computer. There's no software in India. And the worst thing is that it says for it clarifying the doubts that software is considered as a royalty. And again, they also made a 916 retrospective amendment on bandwidth charges, again going from 1976, when the entire Copyright Act as well as other relations came later on, the technology developed later. The retrospective amendment cropped up. In between, section 90 subsection 2, there is one notification was given about the software with the definition of royalty and unilateral notification. So the government tried to tax software through unilateral notification. And on the other hand, they're amending the treaties, some of the treaties like Kazakhstan and Tajikistan, where the other country would not have much trade with India, where they'll make a definition royalty includes software. There's a computer software is part of the definition of royalty, particularly in third world countries where they would not know what is software. They would make that amendment, but with developed countries, they would not do anything. And this sort of a play was done by the government. I'm very happy. I'm extremely happy to note the judgment of Supreme Court for 3 reasons. Supreme Court pointed all these deficiencies. In fact, on 916 retrospective amendment, they said you can't have retrospective amendment when the subject itself was not there and the copyright itself was not there, or the bandwidth charges is not there, you can't have retrospective amendment. Similarly, the Supreme Court also made a distinction between the definition of software as well as the DT and others. And more important, the term software and how the conditions of software, what purpose it is used, Supreme Court made a very detailed, elaborate judgment. Though I respect the government for the way they put forward their views very vigorously, and including stating that TT cannot be applied for definition of software to the extent of going extent. Article 22 even does not apply to the extent of going that. But having said that, certainly this software ruling is a very, very important, very critical from an industry perspective. And very often I had one fear earlier that there will always be a retrospective effect amendment nullifying a Supreme Court judgment, which we saw in the last budget of Supreme Court amendment Smith Securities, where goodwill depreciation was taken away by the retrospective amendment. I was thinking whether any retrospective amendments can come nullifying this, but for already the retrospective amendment has been rendered invalid by the Supreme Court. So there cannot be any amendment right now. Only the treaty negotiation will have to take place in a different way. But definitely the Supreme Court judgment is a very well authored and very well articulated by both sides. And the final point is that due to the Supreme Court judgment, there will be enough amount of free funds will have to be given by the departments. Particularly in the Bangalore industry, every company has paid taxes on, because if the software I have not paid taxes, I will have a disallowance under 40I1. I will have a 201 issue. I will have both issues. A lot of companies paid taxes under protest and they've gone on appeal. Now the department will have to issue a refund. And I know very well some of my clients and some of the people where we have filed went on a mutual agreement proceeding with some of the countries and said software is brought to tax. Now with the Supreme Court judgment, all those things will settle for the dispute. So I'm extremely happy on this judgment, and I'm sure not only from a technical perspective, but also from the flow perspective, how a subject has to be approached. Supreme Court ruling is an eye-opener for everybody. With these few words, I definitely I would like to introduce Mr. N. Venkatram and S. Ganesh. N. Venkatram needs no introduction for Bangalore Chamber of Industry and Commerce. He has dealt with some of the major subjects, including first when triple talaq judgment came, Mr. Venkatram made a presentation here. Subsequently, Mr. N. Venkatram dealt on multiple subjects with Bangalore Chamber of Industry and Commerce. Till 6 months back, he was arguing for all the taxpayers. Now, in the last 6 months, he has become additional Solicitor General. I am not saying he'll argue for the taxpayer, but his role has undergone a change. He has become additional Solicitor General, very well knowledgeable and very thorough person, a thorough gentleman, whom the relationship and the friendship between me, PVS, and Bala with Venkatram goes back to ages. So we cherish that friendship, we cherish a relationship, and we still continue to. In fact, Bala, when told me, said Venkatram is speaking, I said he has become ASG. I don't know whether he has got a protocol to speak or not. Please check, Bala. No, Shekhar is willing to speak. There's no protocol for him. I said I'm happy about that. So thank you, Mr. Venkatram, for joining and giving your views. Mr. S. Ganesh, I've been fortunate enough to work with both the senior advocates here, both Mr. Venkatram and S. Ganesh. And S. Ganesh is absolutely a lawyer. And one thing I love to take Mr. S. Ganesh is that he has given multiple judgments, which are all the what I would call a path-breaking judgments. Probably would have read, some of you would have read the Dalmia Brothers amalgamation ruling the last couple of years, last year in Supreme Court, where the Supreme Court talked about the revised return of filing. He also argued about liaison office, despite liaison office considered a branch of project office. Project office was not considered as a permanent establishment. In another Korean company case, was argued by Mr. S. Ganesh. He argued for me for 2 advance rulings before the AR, where he said the indirect transfer is not taxable. So I can keep on talking about Mr. S. Ganesh exploits in the tax and before the High Court and the Supreme Court. But suffice to say that he is one of the highly respected lawyers who practice in all the high courts and a highly respected senior lawyer advocate in Supreme Court. Thank you so much, sir, for taking your valuable time and sharing your insights on the Supreme Court ruling to all of us. And definitely at the end of the ruling, at the end of the session, we'll be much more learned. Though as a person, I'm always a little bit pro-taxpayer and the pro-assessee. I don't know whether after this discussion, whether my perspective will undergo a change or not, I do not know. But certainly, I look forward to this interesting deliberation. Thank you, sir. Back to you, Bala.
Thank you, Shekhar. Now I request, without wasting much time, I'll request Mr. N. Venkatraman, the the Additional Solicitor General of India to give his speech on the subject.
सुधाकुंभ विबोधमुद्रा विद्याविराजत् करवारिजाताम् अपारकारुण्य सुधाम्बुराशिं श्री शारदाम्बां प्रणतोऽस्मि. Dear BCCI, I'm very happy to be back after a year, after the budget speech last time and the talk on cryptocurrency. There was a gap of about 10 months, after which now the trio has brought me back to speak to you all. I should first be very grateful for 4 people. Ranganathan sir, Madras EY, earlier partner, who brought me to this branch of law. I was otherwise an indirect tax lawyer. And my teacher will, shall, and had always remained in this branch of law is P.V. Srinivasan. You should all, whoever gets an opportunity to learn and work with him, it's so enriching. He started teaching me brick to brick. From say last 15 years, we have been journeying together, learning this law. And of course, the super senior vice president, Mr. Shekhar. Shekhar, you're happy now? So, Shekhar has again put me on the mat in difficult matters. And yes, of late, in the recent past, in the recent years, it has been an enriching journey with Bala. So, if I have some acquaintance in this branch of law, I owe it to all the 4. And in transfer pricing, I owe it to Ashima Gupta, who should be some 20-25 years younger to me. She was in the, I don't know where she is now. She taught me the first lessons of transfer pricing. So it's very important that you come into the right contact at the right time to learn. And that's how knowledge, you accumulate knowledge with basically strong fundamentals. Right. Now, as Shekhar was saying, the past 9 months, 1/4 of my tenure is already over. I'm happy about it. Out of 36 months, I've completed 9 months. So I'm just looking forward to finish the balance 27 months and then be back to do whatever I was doing before that. So this 9 months, I should say, has been extremely enriching. And it is important that every counsel who has been arguing for the trade at some point of time serves one term for the government to understand those nuances. So I have the advantage only because our government, the functions, the administrations, the multiple angles, extremely plural in thought process and deliberations. So it's a ocean. So going by the mix, still 9 months back, I had fought cases on software here and there for Wipro and other companies saying that it is not taxable. I do agree. And that's one of the reasons that I didn't prefer to also appear in the Supreme Court. But after the judgment, I thought working into it, reading into it, it's one of the finest judgments because it has been authored by one of the greatest judges, erudite scholar, very learned and extremely eloquent and pinpointed. And it has been represented by a galaxy of stars for the assessee and also ably represented by Balbir Singh as Additional Solicitor General, duly supported by the International Tax Department. So any young, especially upcoming professionals, chartered accountants, employees in software industry, this is a judgment which all of you should read for understanding a lot of basic things. Having said this, now that, in fact, I issued only one caveat to Bala. Now that I'm a law officer, will I be entitled to speak my views in favor of the government to say that there is still, it's the last ball is not bowled or the last wicket is not taken. Do we have a chance and can we ventilate my views? He said, yeah, it's an open forum. Please do come out with your views. So people who know me, don't be surprised if I'm going to put a counter view now. It's not with an attempt to put, it's a intellectual forum. All of you are extremely learned and I've learned from every one of you here. Therefore, we should deliberate whether there is a possibility, whether all issues have been decided once and for all And is this the end of the road, or it will still unfurl new surprises in the path in the future? That's how I put it that way. Because this is how law is all about. There is no finality to law, as there is no finality to life journey. So it keeps changing, it keeps evolving, and now we have evolved to a fairly great extent in this 20 years. Shekhar was capturing the history. 20 years of his history has now come to a culmination. And we can't be suddenly saying this culmination is wrong and all in just with some open word-minded statements. That's not how we approach it. But there are still some issues which I thought I should put it across. 2-3 things. First, let me put it before I venture to speak on what I share as issues which needs deliberation. First point, which goes well with this judgment, is they have made it very clear that treaty, the option to use treaty or act will vest only with the assessee and not with the government. That's come out extremely certain, reiterating the principle laid down in Azadi. And the reason they have given is following Azadi, and it's a very, very important point as academicians, intellectuals, and also as practitioners, one should know. See, according to any tax law in India, the ultimate in a tax provision is the charging section. You can't go beyond the charge. But Income Tax Act is very interesting. Even the charging section is amenable to something else. Unlike other charging sections where it is either notwithstanding or overarching, Section 4 is subject to. That's the important dimension which the learned judge has explored in laying down his law following Azadi. So income tax law is subject, Section 4 is subject to other provisions. Both Section 4 and Section 5. Section 5 is assimilation of the various kinds of ascertainment of incomes. Therefore, 4 and 5 is subject to 90. That's how it has constructed it. And it is therefore subject to 94. And consequently, assessees have the option to decide whichever is beneficial out of the two. So this is a fairly clear law, but it has been reiterated with absolute in an unambiguous terms in this judgment. And it's actually helping us indirectly even to the government in fighting certain important international arbitration, tax arbitrations all over the world. I don't want to be discussing those points at this moment here because we are all shaping those dimensions before the various courts outside the country. But this is something very, very unique because we do enter into treaties for multiple reasons as a country. But there are some treaties which, if you see Article 253 of the Constitution, if treaty has to be enforced, it has to be enforced through a legislation by the Parliament. But there are exceptions to that because treaty making, unlike Canada or other countries, in India, treaty making is an executive function and not a legislative function. It is a union cabinet which ultimately approves a treaty. So whether to table it to the Parliament or not, it's the discretion. They need not have to do it every time. So in hierarchy of norms, legislation is different from an executive decision, whereas when it comes to double taxation agreement, it gets infused into 90 through a notification. It gets that character, even though it is not placed in the Parliament. And there is a clear overarching provision of 94 which says assessee will have the choice, whichever is beneficial to him. So you don't find that in similar international treaties, even assuming they deal with or they have an occasion to deal indirectly tax issues. So this is a judgment which will help Government of India in some way in fighting out certain important arbitration matters. This is one take. Now the second take is, this is where the first signs of concern, I thought I should ventilate it. Even though Supreme Court has classified it into 4 buckets, you can put it broadly into 3. The EULA type is one, ultimate user like you and me. Then the second vertical is the redistributor, the distributor and the redistributor. And the third is the customized software working through a service contracts. Works contract, service contract, work order, you call it, different names are being used. Now, the court has concluded all the three to be not taxable. That's something which, and it gives very, very valid and strong reasons. For EULA, it makes it very clear, look at this, you go by 14, you go by 52. And you, unless there is an infringement, we can't call something as taxable. So infringement is the ultimate point, because copyright is a negative right. Unless you show that it's not infringed, you cannot touch it as a copyright. And they say taking spare copies, taking multiple copies, take for your own personal consumption, not for sale. All those exceptions have been neatly categorized in the judgment. So it read 14 with 52 and articulated the point, EULA is out of taxation. That's the logic it has gone into. When it comes to distribution, this is the reason the Supreme Court says in several places. It says, see, Shekhar was talking about the sale of a book and the sale of a software. That is how TCS has perceived it. And that is how this judgment also perceives it. In fact, Justice Nariman exactly refers to the sale of a book as a comparison in deciding the taxability of royalty. But there we have some reservation. Just it's a discussion point. As I said, best efforts have been put by everybody, but it's a discussion point. What is the discussion point? See, the need for introducing 14b2. 14b2 of the Copyright Act is exclusive only for software, not for any other product sale. And 14b2 uses the expression copy. It doesn't use the expression copyright. A distribution or a sale or a commercial renting of a copy is deemed to be a copyright. So we have to, this is something which needs to be isolated first as a category, as a classification. Because every other right, you sell a book, there are so many copyrighted articles which are sold in the market through a distribution process. But none of them fall under 14b2. Only software falls under it. Now the Supreme Court has brought this category also under 14a by default, and virtually applied the same tests which it had applied for EULA under section 52, and therefore came to the conclusion, even in the case of a sale or a distribution or a commercial rent, the acid test is, does the distributor have the right to reproduce and sell? If it doesn't have the right to reproduce and sell, then you can't tax it as royalty. Now, there are three, commercially, there are three stark distinct aspects which all of us are very familiar with. Right to reproduce is a separate right. Right to use is a separate right. And right to sale or distribute or give it on commercial rent is a separate right. All of them are not one and the same. You can't equate use with reproduction, nor can you equate this category of distribution right as at par with reproduction. Now, it's not that the Supreme Court has done it without reasons. The court gives only one reason at all the places. The reason it says is, look here, there was an amendment, there was a law prior to 2000, which said in the same 14b2, irrespective of the fact that the copy has been sold or hired or given on commercial rent on an earlier occasion. Now it says that this phraseology has been actively removed from 14b2 by the Parliament. So you must give a meaning to it. You must give an import to 14b2, and it therefore concludes, having removed this amendment, you necessarily have to read reproduction as a prerequisite even for 14b2. Now the concerns, this is at this point of time, these are my personal views, but as a law officer, I'm just trying to ventilate my views. voicing it in favor of the government. This is a personal view at this point of time, and therefore I want to put that caveat very clearly. Now, if you read this deletion of the amendment, this, according to me, this deletion is only a deletion of a surplusage. You don't need this provision at all. It was just in excess than what it served. Why? After all, 14b2, exceptional circumstances for distribution. 1. In exceptional circumstances, identifying only software and no other product. 2. And 14b2, even in its present form, refers only to a copy and not a copyright. It deems a copy to be a copyright when distributed, sold, or given on commercial rent. So the expression, irrespective of the fact whether it was sold on an earlier occasion, what does it mean? One view is this only talks about the chain of distribution from a wholesale to a retail to an actual consumption. Suppose there are 4 tiers of distribution and the same product has traveled 3 tiers. It is not going to be a vitiating factor against it. Every tier, it will be a 14b exercise. As long as there is a right to distribute, then it becomes a copyright. Now you remove that. You just remove this phraseology which was deleted in 2000. It will still be a sale of copy. So it is the test that could have been applied is what was the meaning this phraseology actually gave? What purpose did it serve prior to 2000? And what purpose did it deviate or seek to achieve by its denudation? That's not there. Therefore, it is possible to say it is only a surplusage. Because this is one reason. The second reason is, if you're going to say reproduction is read into 14b2, then reproduction is already there in 14a. You are replicating one more test into 14b. Is there a requirement? Can we do that? Is it permissible? Is something which we need to explore as a second possibility. And third, more importantly, is when the reference is with regard to software, sale, and a copy. How has the denudation of this amendment brought it back to its original status? Then there should have been a deletion of 14b2. Today, you can say that 14b2 stands denuded, or 14b2 has been recharacterized as a condition mandating reproduction. So this is the concern when it comes to the distribution vertical. Now come to the third vertical, which is the works contract vertical. There again, efforts have been put by the Government of India in very firmly in placing the decision of the AutoCAD decision, and the court has discussed it at length. It has referred to the judgment. It has expressed its views very firmly. But what I found out if a youngster can do that deciphering, it will be very helpful to everybody. If you see the conditions and stipulations found in AutoCAD, and the conditions and stipulation you normally have in a customized software, they are invariably overlapping. They will match 8 out of 10, 9 out of 10, 10 out of 10, 11 out of 10. In fact, it extracts. The learned judge has extracted the portions and has also underlined it, highlighted very meticulously. The effort has been made to bring on record the submissions, and it is in fact a very good submission, I should say, made by the Government of India. So, after comparing it for the third vertical, the court, and then it deals with the option of right of first sale. It takes AutoCAD, takes works contract, and goes to right of first sale, goes through the decisions on Wright Warner Brothers, etc., and comes back to say 2000 deletion is very, very important, and therefore that has to be read even here. Therefore, a sale at the first option, it gets exhausted, and unless you reproduce and sell, even a customized software will not attract royalty. So the flow has virtually been in all the three verticals, whether it's EULA or say distribution or say works customized software, the bottom line looks to be reproduction. It is virtually a vanilla 14A read with 52. This looks to be the contours on which this judgment has been delivered. So now that you're all pundits, you have all been working with this case for the last 2.5 decades, from 95, 96, or possibly from 2000, at least it is 2 decades old. You can find out when this is one area which in my personal view, whether the court should have proceeded it on this way. This is one point. I have a larger point. Very importantly, I have 3 submissions to make here. What's the time? I have 3. Ganesh sir, I'll take about 15 more minutes. You're okay? Okay. 10 to 15 minutes and they'll give it to you. See, 3 aspects I thought I'll place it on record for consideration. Now, there is a 2012 amendment in the Income Tax Act introducing explanation 4. Clarifying that it was the intention of the Parliament always to tax software. Now, Vodafone also got overturned through 2012 amendment, of course, through a separate genre. When they did an explanation 4 in 916, there was a simultaneous explanation 2 introduced in 195 also. Somehow the court has not examined it in this case. There is one explanation in 195. The normal assumption of that explanation under 195 is it applies only to transfers of shares outside the country by the seller and buyer being the foreign territory. That's the normal conception. But there is a possibility if you read that explanation under 195, it says all persons, residents, non-residents, including the seller and buyer and the property located outside the country. It virtually covers all the 4 categories of taxpayers. So this is what is something which has to be examined at some point of time by the court in this case or in some other matter. That's why I said the law is not a final destination. It's a progressing, evolving law. This is what I have to share. Again, at this point of time, it's a personal view. 1, see, you must see the purpose of explanation 4. For example, in this IHI judgment on international taxation law, the moment the judgment got delivered by His Lordships, as he then was Justice Sinha, there was a retrospective amendment of 917. That was a vanilla amendment going back without a conflicting precedence. But you can't say that for software. In software, in fact, Super Vice President Shekhar was narrating, there was utter confusion about its taxability, not only at the field level, not only at the appellate level, not only at the tribunal level, even at the High Court level. So you had different strong views on the subject. So there was uncertainty. So when there is an uncertainty, when Parliament introduces an explanation to say, this is our view, we have always found this to be taxable. Now, correspondingly under 195, there is an explanation which says, we have always thought these are taxable and therefore there's an obligation to withhold TDS. Now, the first singular point that requires an assessment is, was the court correct in concluding that this is a case where a retrospective TDS is sought to be withheld, completely untenable, therefore it is incorrect and illegal? NGC networks, etc., etc., etc. A line of judgments have been referred to and followed. My concern is all those judgments were judgments rendered prior to the introduction of the explanation. That's the law. You can't think of a retrospective TDS. It's impossibility. Lex cogit, Krishnamurti, line of judgments are there. Absolutely, the law is very clear. But whether the law will apply to the present facts is the question. Because you have divergent views. And an explanation has been introduced. And an explanation has also been introduced for withholding of TDS, making it clear we have always thought it is liable to withholding tax. So, can you plead impossibility at this stage? Is the court therefore right in concluding in the given background of conflicting of views? This is, I feel personally, a fertile area where we need to explore both ways. So this is as far as the income tax is concerned. Of course, you will immediately, all of you will trigger me back and say, come on, forget. We have the overriding treaty. The assessee has the option under the treaty. When Article 12 in most of the DTA say that royalty is not taxable, you can decide anything. You can't still put us because I have the benefit. And once you succeed in treaty, the question of a TDS doesn't arise. That's something which this judgment makes it very clear and maybe right also. But I have a concern there also. That's the third point which I want to flag off for the. See, this is the hub. Bangalore is the hub of software. And therefore, when BCIC said that we should address, and BCIC is not something new to me, I've been doing it for years. So I thought that it's an opportunity to voice some of the views which can possibly, if government finds it fit, can consider. See, the third aspect, as we have conflicting views emerging even at the High Court stage in India, and therefore a need for a clarification in both royalty definition and also in the TDS provision. The international scenario is also not very consistent. It may be 90%, 80%, 95%. It's all a variation of degree, but you also find Australian view to be singularly extreme. You also find the technical report of US to be something which you can interpret. And high-powered committee in India has expressed its view that this is what we feel. So suppose Government of India is able to establish that there are doubts, even doubt could be 1:90 or 10:90 or 50:50. There is no question of, it's a question of not a vanilla case. To say that the international perspective on software is it can never be taxed for royalty. We can't say it. Such a statement cannot be made, and such a statement has not been made also in the rightly by all the galaxy of participants. They rightly said that. So when this is the confusion or a doubt emerging in the international scenario, it is imperative for a law to be laid down by the Supreme Court at some point of time. How do you decide then a provision of royalty under Article 12? Because if one can rely on, say, India-US treaty, somebody can rely on India. So same expression, if there are multiple plural views to it, you can't say it is a uniform view or an accepted view or a view which is without controversy. In such scenario, how do you interpret the law? Whether you should also take cognizance in those circumstances how the local nation, how the nation has its flavor and its idea, its theme of taxation. Should it be a tool in interpreting? This is an area which needs to be explored, and therefore it's not as though that the international view is completely clear. Now the fourth point, which is the last point after which I would hand it over to Mr. Ganesh. The fourth and the last point is, see, when it comes to the OECD commentaries, I see three variations as a matter of fact. Variation 1, India accepting the OECD position. Variation 2, India expressing reservation. Variation 3, India rejecting or disagreeing with the view. Now, the Honorable Supreme Court in this judgment has considered only 2 and 3. And it says reservation is not equivalent to dissent. And because there is no dissent, then we should, even Indian view or the government of India's view is in line or sync with the OECD view. And therefore, OECD view, we have been using it in our courts as a referential document. And therefore, why not that view prevail? So the doubt there again is, there is no, see, we have to, the OECD view has different shades, where you accept, where you reserve, and where you dissent. So if you reserve your view, you have not conceded to your position of taxation, is one possible point which needs to be again explored in some other matter at some point of time. And so, well, there are 4 or 5 in this 30-40 minutes. I think these are at this stage personal views, though it is in favor of the government of India. I have not discussed it with anybody else. These are my personal views. I have to put that caveat again, and we will see how things shape in future. Whether the last ball is bowled or the match is won, we don't know. Let industry be happy as on date, because you must feel the success because you have fought for it for 20 long years, and you have reached this. So what is in store for future? Well, let nature reveal it at an appropriate juncture. I must thank my teacher PVS, my good friend Shekhar, Bala, and I don't know, Ranganathan sir, watch me in case he's listening, all of you, for teaching me the basics and providing me with the opportunity to come to this stage as a direct tax lawyer also. It is a pleasure to have addressed each one of you. Let Mr. Ganesh speak, and I have a lot of respects for him. And once he completes, either questions or if there's a need to clarify, I'll wait for my turn. Pleasure. It was very, very nice talking to each one of you. Namaste.
So thank you very much, sir. Now I request Mr. S. Ganesh, Senior Advocate, Supreme Court of India, to take over the proceedings and address the gathering.
Friends, it is an honor and a privilege to participate in this webinar. Listening to Mr. Venkatraman, I could not but help thinking that this was a very eloquent and persuasive presentation of the government's proposed review petition seeking a recall of the judgment in the software case. So let me modify and modulate my address, keeping that very much in mind. I have always believed that a careful study of the reasoning in leading Supreme Court judgments, and in particular of the grey areas in those judgments, makes us much more agile and nimble and resourceful, and more articulate in presenting our case and also in understanding the finer nuances of the legal issues involved. Now, in this particular case, I think we first need to understand very clearly what is the basis on which, the precise basis and the foundation on which the revenue has, from the very beginning, a good quarter century ago when this dispute began, sought to contend that payments made for these software packages constituted royalty, whether within the meaning of 916 of the Income Tax Act or within the meaning of Article 12 of the OECD Treaty. The basis of the revenue's contention is essentially a purely legalistic and jurisprudential one. And it is this: the revenue has been contending from the threshold that copyright is a bundle of rights, a bundle which is made of many sticks which represent the various rights which are vested in the copyright holder. And the revenue's contention has always been that if even one of these rights, which forms an integral part of the bundle of rights constituting the copyright, is permitted to be utilized either by the software user, the end user, or by the distributor in a legalistic way, then a part of the payment made by either the software distributor to the overseas supplier or directly by the end customer to the overseas supplier, because there could be direct transactions also, a part of that payment would then constitute royalty, because royalty is a payment which is made for a use of a right which is a part of the copyright rights. And then if even a part of the payment made is for the use of a right which constitutes an element of copyright, then if the payer does not want to deduct tax on the entire amount, there is a burden or duty cast on him, an obligation cast on him to make an application to the TDS officer under section 195(2) or 197 of the Income Tax Act for permission in writing, prior permission in writing, to deduct tax on a smaller or lesser amount. If he does not do that, and if he straightaway presumes on his own that, no, I need not go to him at all because according to me this is not really a payment of royalty, then according to the revenue, the assessee would be playing with fire and he has to take the necessary legal consequences if it is found that even a small part of the payment can be said to relate to or be attributable to the use of a right which is a part of the bundle of rights which go to constitute the copyright. This, I think it's very important to understand that this is essentially the legalistic or jurisprudential foundation on which the department has erected its entire case from the very beginning for the purpose of saying that the payment constitutes royalty and it was your duty to come to us. We would have then considered it liberally and we might have permitted you to deduct it on a smaller amount. But you never came to us and therefore you are an assessee in default. And if you are an assessee in default, the consequences are really indeed terrible to contemplate, because not only do you become liable to penalty and interest, pay the amount of tax and interest thereon, you're also liable to face a penalty. And apart from that is the horrible consequence of complete disallowance of the payment under 40A1. And if a distributor is operating on a 2% margin, and if the 98% which he pays to the overseas supplier gets disallowed, then it is a fate worse than death for him. Now, what is the basis on which the department has been contending that there is an element of use of copyright and therefore a part at least of the amount constitutes royalty? It's a little important to understand the basis of the contention of the department so that we can effectively deal with it and repel or rebut it, should it at all be possible, after hearing Mr. Venkatraman. Right. Now, the department seeks to contend that the customer, the end user of the software package, has been given a license. He is first given a license, obviously, to use the software because otherwise he wouldn't buy it. That itself, according to the department, on various foreign authorities, constitutes an element of user of the copyright, though that is highly debatable. But more importantly, the revenue has always sought to contend that the customer has been given a license to copy that software onto his hard disk and also to make a backup copy of that software in case of emergency. And making a copy of the software package is an essential and fundamental part of the rights of the copyright holder. And therefore, to the extent to which that license has been given to the user of the software package, he is given a license to use the copyright, and therefore a part of the payment at least which is being made by him, either directly or through the distributor, constitutes royalty. Now, so far as the distributor is concerned, the argument is that he has been given a license to sell the copyrighted software, and the very act of being given the license to sell that copyrighted software itself constitutes, without anything more, and especially having regard to the wording of section 14B of our Copyright Act, an element of the overall rights of copyright has also been given to the distributor for his use, and therefore at least a part of the payment which he makes to the overseas supplier of software constitutes royalty. This is essentially the case of the department, and it needs to be understood very carefully and clearly that this is a purely legalistic and jurisprudential way of looking at the transaction, characterizing it, and then describing the nature of the payment which is made and the nature of the income which is generated. And why do I emphasize these words? Characterizing the nature of the transaction from a purely legalistic and jurisprudential point of view, I will come to in a little while when you will understand the significance of why I am saying this perhaps more than once. Now to this purely legalistic argument of the department, there is also a legalistic answer which can be given by the SSC. And that answer is this, that under section that there is a huge distinction between a sale on the one hand of a copyrighted book, a copyrighted audio disc and a copyrighted DVD on the one hand, as compared to a sale of a copyrighted software package. And that distinction is this: when the book is sold, nothing more is required to be done to complete the sale. The buyer can straight away read it, he can straight away use the music CD, he can straight away view the DVD. Nothing more is required. And the very act of sale to him constitutes, I mean, it is a commercial article. He has purchased it as a commercial article. He has paid sales tax on it. The vendor has charged him sales tax. And if it has been imported, customs duty used to be paid in the past on it as a commercial article. And therefore, nothing more is required to complete the sale. In sharp contrast, a software package cannot, in the very nature of things, at all be used unless a copy is made, first on the hard disk and a backup copy for emergencies. Therefore, to complete the sale of this commercial article, of necessity, you have to give either expressly or by necessary implication the permission to copy it on the hard disk and to make a backup copy. Now, this is not something which is being advanced as a novel legal argument at the bar. It is something which the legislature was fully conscious of, which is why Section 52(1)AA of the Copyright Act expressly gave permission, irrespective of the terms of the contract between the software supplier and the software customer. It expressly gave a statutory right to the customer to make a copy of the software on the hard disk and also to make a backup copy for emergencies. Now, therefore, even if there was no contractual license granted by the software supplier to the customer, the statute gives permission to the customer to make a copy. Now, if the statute gives him permission to make a copy, then the question which arises is, if there is a license and a contract, and under the contract express permission is given to the customer to make a copy, would it really constitute a license to use the copyright or not? This is where Section 52 of the Easements Act comes in, because it defines the term, the crucial term license. And the Easements Act Section 52 says, a license means permission to do a thing which, but for the grant of the permission, would be illegal. So here, even if no permission had been granted by the software supplier to the customer to make a copy, it would still be perfectly legal for him to make a copy having regard to the statutory permission given to him by 52(1)AA, and therefore the term or condition in the license, which is a part of the software package which the customer opens, is really cannot be described as a license at all. Now, this is independent of the other points, as to whether the distributor of a software also has been given a right to use the copyright or not. On that, he certainly, without any doubt, the very fact that he is appointed as a distributor means he is permitted to resell the software, and according to the revenue, that itself constitutes in law the grant of a right to use the copyright which belongs to the copyright owner. Now, I have given you a very highly simplified version of the legal arguments which were advanced before the Supreme Court. To show that it involved legalistically and jurisprudentially a user of the copyright rights, a mass of material was placed before the Supreme Court. The paper books run into 1,000 pages for the revenue itself, and I think about 750 pages, various compilations which were filed on behalf of the various SSCs. These compilations included various judgments from a variety of jurisdictions, USA, Europe, Australia, UK, and so on, all for the purpose of saying that these are the subtle nuances of the law of copyright as it has developed through the ages, first as a common law right and subsequently codified and explained by statute. And therefore, according to this mass of learning, erudite learning, it can be said that there is a user of the copyright which is involved, an element of user of the copyright which is involved by the distributor and also by the end customer. Now the Supreme Court, it's important to note, the Supreme Court took 6 whole days to digest this enormous amount of volume of material. And for the purpose of reaching a conclusion as to whether, from a purely legalistic point of view, looking at this elaborate doctoral dissertation of the subtle nuances of the law of copyright, it can be said that there was user of some element of the law of copyright by the distributor or by the end user. But the question which I think we have to ask ourselves is this the burden which the law casts on the person making a payment for a software package? Now, therefore, we need to understand clearly what is the correct approach. And as always, I think the answer to a difficult question emerges only when we pose the right question and put it to ourselves ruthlessly, remorselessly, and relentlessly. Only if we ask the right question, we get the right answer. So the right question, according to me, is not whether from a purely legalistic or jurisprudential point of view, at the end of the day, there is conceivably user of some element of the right of copyright, one small stick in that bundle, either by the distributor or by the end user. That, according to me, is not the test. We are dealing with the DTAA. The DTAA overrides section 916 because it is universally acknowledged and admitted, even by the revenue, that the definition of royalty in the DTAA, in all the OECD DTAs and the UN model DTA as well, that the definition of royalty there is much more limited, less restrictive and less onerous, and therefore more beneficial to the assessee than the definition contained in 916 of the Income Tax Act. And therefore, it would follow as night follows day that DTAA would override completely and totally section 916. Now, therefore, the question that we have to ask ourselves is this royalty within the meaning of the DTAA? Now, DTAA does not give a very elaborate definition of royalty, and certainly it is of crucial importance to note that the DTAA is not a legal document at all. It is a commercial document, and there are judgments which I will refer to presently, which say specifically that you don't expect the same degree of legal precision from a DTAA as you would get from an Act of Parliament, and therefore a DTAA should never be construed like a tax statute, because it is not meant to be treated like a tax statute. It is really a commercial contract between the two contracting nations, and therefore it should be treated as such. Excuse me. Now, therefore, the real question that we have to ask ourselves, and this is the key to the whole problem, I mean the solution to the whole problem, is not whether from a purely legalistic point of view there is user of some element of the bundle of rights which go to make up the copyright, but whether, as between royalty and business income, the two competing heads in the DTAA, which is the more appropriate head to put this payment under? How would you therefore characterize this payment, and what are the principles that you would apply for characterizing the payment, bearing in mind that the person making the payment is not expected to be an expert in the law of copyright. He is not expected to spend one full month looking up all the laws on copyright and then convincing himself whether this payment is really for user of an element of copyright or not, and then deciding whether to deduct tax at source or not. And bearing in mind that if he does deduct tax at source and the recipient who belongs to a different country feels very strongly that this is not a case where tax should be deducted at source at all, then that itself will lead to a very serious commercial dispute. Transactions will get disrupted, and the smooth flow of commerce and business will be gravely affected. And it is to avoid that the DTA has been drafted in a slightly open-ended and sometimes, as the experts say, a deliberately ambiguous way. Now, therefore, we need to understand that the DTAA is not a legal document. It is a commercial document, and I will come to one or two of those judgments which put it very eloquently, especially in Azadi Bachao Andolan. And I will paraphrase just one paragraph from Azadi Bachao Andolan, which says, DTA speaks the language of a diplomat and not that of a lawyer or the language of a parliamentary draftsman. It is meant to smoothen and lubricate the flow of commerce between the contracting nations and therefore should not be construed strictly and narrowly like a tax statute. This is the judgment of the English court in Gladden's case, which has been cited with strong approval by our Supreme Court in the Azadi Bachao Andolan case. And therefore, the transactions, payments and incomes for the purpose of deciding how it is to be classified, characterized and described under the DTAA, it should be done from a commercial point of view and not from a legalistic or jurisprudential standpoint. This is the important point to be noted. And this is again not a totally novel legal argument to put forward, because the doctrine of commercial nomenclature or the doctrine of a businessman's understanding has been one of our basic pillars of tax law, even in indirect taxes. For example, in excise duty, we always characterize and classify products having regard to their commercial understanding, unless of course the tariff entry itself contains a specific definition which is on scientific or technical lines and therefore rules out commercial nomenclature or understanding. To give you a simple homely example, how you can look at it from a different point of view, a lecturer in botany would certainly describe a tomato as a fruit. But if he were to walk into a restaurant in the world of commerce, I think he would be rightly infuriated if the restaurant served the tomato to him as part of a fruit salad. This brings out in an essence the distinction between a purely technical or legalistic characterization and a characterization which bears in mind the commercial world realities and how businessmen are expected to look at a transaction and understand it. Now just see what Azadi Bachao Andolan says. It says very clearly that the transactions, it says it is addressed to the world of businessmen. It should not be construed strictly and narrowly like a tax statute. In fact, it should be, and there are deliberate ambiguities which are left, and the object of the DTAA is to ensure that the flow of commerce is smoothened and lubricated and it takes place in a convenient manner. So therefore, in the very nature of things, the DTAA should be easy to understand, and when a person makes a payment, he should be on exactly the same wavelength as the person receiving the payment, so that both of them understand and know exactly, and they are in complete agreement and in sync with regard to what the nature of the payment is, and therefore whether it requires a deduction of tax at source or not. Now, it is in this context that the OECD commentaries come in. Now, the OECD commentaries have been drafted by distinguished experts who have been drawn from various disciplines. The OECD commentary expressly states that it is addressed to taxpayers who are engaged in commercial, industrial, and financial activities. And the object of the commentary is to ensure that they can plan and arrange their affairs on the basis of the OECD. The OECD commentary, therefore, speaks the language of a businessman. It is addressed to businessmen all over the world. It seeks to understand and then follow their understanding. And most important of all, the OECD commentary seeks to bring about a uniform understanding in the minds of businessmen all over the world, contracting parties who belong to two different contracting parties and who may have a very different cultural background, different languages, but all of them would look at the OECD commentary and then proceed on that basis. Now look at the reliance which has been placed on the OECD commentary by our Supreme Court again and again and again when different types of questions have arisen for consideration. For example, in the Azadi Bachao case, the phrase, it was a purely legal phrase, liable to tax, which in the DTA arose for interpretation. The Azadi Bachao Andolan, the judgment of the Supreme Court decided the interpretation of this phrase by placing reliance totally on the OECD commentary, even though it was a purely legal issue and not a commercial issue. This is the extent of the reliance which was placed on it, And they said, this is a commentary which has been put together by experts, and we must pay it the requisite esteem and respect it deserves, and we will follow it. In Formula One, the issue was, how do we understand the term permanent establishment, and whether the racetrack in India could be said to be the permanent establishment or not. The literature in the OECD commentary which explained what exactly is meant by permanent establishment was strongly relied upon by the Supreme Court, and ultimately it based its judgment entirely on the OECD commentary, and then reached a conclusion that applying the tests which were laid down in the OECD commentary, this property can be considered to be permanent establishment of the British company sitting in the UK. To an even more striking extent, reliance was placed on the OECD commentary in the e-funds case. In the e-funds case, three distinct issues arose before the Supreme Court. First was, what is the permanent establishment, that is permanent place of business establishment? Then secondly, was there a service PE also in existence? And thirdly, what is the effect of a MAP settlement which is reached between the SSC and the revenue in a particular year? For all the three issues, the e-funds judgment placed strong reliance on the OECD commentary. And it is also very important to note that both in the Azadi Bachao case and in the e-funds case, it was the Attorney General who placed reliance on the OECD commentary and commended it to the Supreme Court and said, please follow this commentary. It is completely reliable. It is totally trustworthy. There cannot be anything more reliable than this for interpreting the DTA, and please follow it. This was the argument put forward by the Attorney General in Azadi Bachao Andolan for getting the judgment, adverse judgment of the Delhi High Court, which struck down the board circular which had been issued to facilitate the DTA between India and Mauritius to be implemented. That argument was placed there, and the Attorney General similarly relied very strongly on the OECD commentary in the e-funds case for all three purposes: for understanding what is meant by a service fee, for understanding what is meant by a permanent place of business fee, and also for understanding what are the legal implications of MAP settlement. Now, therefore, I would think that the OECD commentary is of critical importance. Now, what is the approach which the OECD commentary adopts in connection with these software payments? Very interesting and very enlightening. The OECD commentary says, yes, there is permission given to the user of the software package to make a copy, but it is not commercially significant at all. This is a regular article of commerce. It changes hands from person to person like any other goods, and therefore, for characterizing the payment which is made by the user of the software package, we would not attach any importance to this, even assuming, therefore they say, even assuming without conceding that at the end of the day, on a very meticulous and detailed and erudite analysis of the subtle nuances of the law of copyright and taking judgments on the law of copyright from all over the world, even assuming without conceding that the user of the software package does use some element of the copyright which is vested in the copyright owner, it is not significant, and therefore we would not attach any importance to this for the purpose of characterizing the transaction, for the purpose of characterizing the payment which is made in respect of that transaction, and for characterizing therefore the income and classifying it under the DTA, and therefore we have no doubt in our mind that the payment which is made constitutes business income which should come only under Article 7 of the DTA, and therefore it would be taxable in India only if the revenue can establish that there is a permanent establishment which is located in India. Now, if this is the approach which is adopted by the Supreme Court, then the entire weight of learning which is contained in those 2,000 pages of compilations filed before the Supreme Court, the doctoral dissertation on the subtle nuances of the law of copyright, really ceases to be important, because the OECD says, let me assume, OECD commentary says, let me assume that there is some element of use of the copyright. It doesn't make any difference. We will look at it from a commercial point of view. And commercially, the use of that copyright is of no significance for characterization. Therefore, we have no hesitation in putting this as business income. Now, if you do adopt this approach, then I respectfully submit, with all respect to Mr. Venkatraman, that no debate remains at the end of the day. Because this is the approach. You cannot fault this approach because you are dealing with a commercial statute. This statute is addressed to businessmen all over the world. It is meant and intended to enable them to arrange their affairs. And when they make payments, therefore, both the payer and the receiver will look at the OECD commentary. Now, is it then reasonable to say that the person making the payment is expected to make this research over a period of 1 month, as the lawyers in this case, software case did, and then come to a conclusion that no, I can't place reliance on the OECD commentary and I will have to deduct tax at source? What will be the consequence of that? The commercial relationship between the payer and the receiver will be sorely disrupted, because the buyer would be entitled to put forward a grievance and say the OECD commentary is crystal clear. This is not royalty. This is business profit. And I don't have any establishment in India at all. How can it ever be taxed in India? So please don't deduct tax at source. This is not acceptable to me. It will give rise to commercial disputes. It will give rise to disruption of commercial transactions. And that is and to avoid those is the very object of the DTA. That is the very object of the OECD commentary. And therefore, I would respectfully submit that the OECD commentary neatly bypasses and cuts at the root of this extremely highly technical and legalistic argument that there is user of an element of copyright. Therefore, I would respectfully submit that if this is the right approach which is to be adopted, a commercial nomenclature approach, the businessman's understanding approach, as reflected in the OECD commentary, then there is really no scope for doubting the judgment of this judgment, because the latter half of the judgment is based on the OECD commentary, though the first half of the judgment does make an elaborate analysis of the law of copyright, on which perhaps two opinions can be expressed. But on the latter half of the judgment, I would respectfully say that no second view of the matter can possibly be thought of. Now, let me also deal with one or two other further issues. The Supreme Court has given a categorical finding that a person who makes a payment is entitled to place reliance on the OECD commentary. So, in other words, no further burden is cast on him. He does not have to become a legal researcher. He does not have to go through hundreds of volumes for understanding the law of copyright. He can place reliance on the OECD commentary and say, this makes it clear it is not royalty. I will not deduct tax at source. And he can never be considered to be an assessee in default. I would respectfully submit that this goes a very, very long way in giving commercial efficacy in a most beneficial manner to the DTAs and achieving their avowed purpose of lubricating and facilitating the world of international commerce. The second important principle in this connection, which was laid down by the Supreme Court, in this judgment is that even if our government has reservations or objections to the OECD commentary, this was also what Mr. Venkatraman referred to, that we are not completely in agreement with the OECD commentary, even though so far as software packages are concerned, the voice of the government in raising its objection is very muted and very faint. It just says, it refers to about 6 different articles, 2 of which are the 2 articles, paras in the OECD commentary dealing with alleged copyright use by the user of the software package and alleged copyright use by the wholesale vendor. And it says, we are not altogether in agreement with all of this. We are not sure. They don't even identify the area of difference. And that was first articulated in 2008. But after that, they have not converted it even into a full-blooded objection. But what is most significant is the Supreme Court has cited with approval the judgment of the Delhi High Court in New Skies Satellite BB 382 ITR 114, which lays down that even if the government has put forward a full-blooded objection to the OECD commentary, that objection is of no consequence unless the government goes and renegotiates the DTA, because it can never be amended unilaterally, even by a retrospective amendment made by our legislature. This is a principle of the utmost importance, and therefore it makes sure that, and the Supreme Court has also noted that when it came to software, many of these treaties, including the treaty with Singapore, was renegotiated. when it was renegotiated, our government made no attempt at all to change the definition of either software of royalty or to bring in software payments or anything of the kind. Similarly, two other cases also, there were renegotiations of treaties, and even though they had the same definition of royalty in Article 12, the government made no attempt whatsoever to change the definition of royalty. So the government, see, the Supreme Court has made a note of that and said they had the opportunity, but they chose not to avail of it. How then can they now turn around and say that we don't rely on the OECD commentary, we don't agree with it? Apart from this, it is also necessary to note that faint objection put forward by the government that we are not altogether in agreement with the OECD commentary was first articulated as far back as in 2008. In 2010 came the excellent judgment of the AAR in Dassault. I'm not saying it is excellent because it was in favor of the SSC, but it is a closely and meticulously reasoned judgment by the AAR presided over by retired Justice, Supreme Court Justice Venkatrama Reddy, and I in fact made a statement to that effect in the course of my arguments before the Supreme Court that this judgment and order of the AAR compares very favorably with any Supreme Court judgment or any High Court judgment on a tax matter. This judgment in the year 2010, even though it was fully aware of the so-called reservations made by the government in 2008, nevertheless placed complete reliance on the OECD commentary, and the government accepted that judgment and allowed it to become final. Of course, it is res judicata only as between the persons thereto, but this judgment in Dassault was followed by a large number of high courts all over India, and many of those high court judgments also remained not appealed from, thereby clearly indicating, I'm not saying that the rule of estoppel operates here. This again is a slightly uncertain area of the law. What happens when you don't file an appeal, and whether the principles laid down, for example, in there are 2 or 3 judgments of the Supreme Court which lay down the principle that if you have accepted a principle laid down by one high court and not appealed against it, then you cannot argue to the contrary before another high court. Berger Paints is the classic example, but be that as it may, let's not get into that because there's not enough time for that. So the Supreme Court has also relied heavily on the Dassault judgment of the AAR, thereby putting its mark of approval on the Dassault judgment. Now, therefore, on this basis, I would respectfully submit that if we look at it from this point of view, and if we characterize the payment adopting the basic test of commercial nomenclature, and that commercial nomenclature being reflected very eloquently and very clearly in the OECD commentary, the OECD commentary also deals with the alleged use of copyright by the distributor of copyright, and it says he is only given that right which is necessary to enable him to resell because he is a distributor. Therefore, whether there is an element of user of copyright or not is of no significance for characterizing the transaction. It still remains business income and has to necessarily come under Article 7. This logic, I respectfully submit, which is enshrined in the latter part of the judgment, stands out in stark contrast with the very detailed and elaborate debate in the first part of the judgment, which deals with an analysis of copyright rights, analysis of section 14A, the 14B, the amendment to 14B which was made in 2000, the deletion of those crucial words, what exactly is the effect of that deletion, all that really, in my humble submission, they recede into insignificance if you adopt this basic test of commercial nomenclature or commercial understanding as reflected in the OECD commentary, and we place reliance on the Supreme Court's decisive, and this is a 3-judge bench of the Supreme Court. It can only now be upset by a constitution bench. It says very clearly a person making a payment is entitled to place reliance on the OECD commentary, and if the OECD commentary tells him that this is not royalty and is therefore not taxable in India, he is entitled not to deduct any tax at source. He is fully at liberty not to go to the TDS officer and make an application to him under 195 and 197 of the Income Tax Act. This, I respectfully submit, will stand the test of time, and even though there may be resourceful and eloquently argued review petitions presented by government law officers, I dare say, and I say this with some degree of confidence, this part of the judgment will remain unshaken in the times to come and will protect us forever. Thank you. I had selected 2 other judgments also for
Thank you,
reference, but I don't think time will permit that. So I'll
Thank
leave
you.
it.
Sir, if you want to take 10 minutes to shortly summarize those 2 judgments, we have time.
Okay, all right. Okay. I had
And then we
selected-
will have Mr. N. Venkatraman, to respond if
Yeah.
necessary.
Sure,
And
sure.
then we'll have Mr. Srinivasan summarizing the whole discussion.
Sure. I had selected 2 other judgments because of the importance of the legal principles which are laid down in those judgments, which go far beyond the ambits of those cases and which affect a wide spectrum of cases. One of them was in favor of the SSC and one of them was in favor of the revenue. In one of them, in fact, Mr. Venkatraman was on the other side, and I was fortunate enough to succeed. But now that the case is over, I can share with him something confidential, that after hearing his argument, my client was really in grave doubt about whether we would succeed or not. So, now, in Samsung, the basic facts are very important. It was a turnkey contract which was awarded to a consortium. The consortium consisted of Samsung Heavy Industries and L&T. And the project consisted of first designing, engineering, and fabricating an oil exploration platform abroad, then bringing it to the western coast of India, and then erecting it and commissioning it, and so on. For this purpose, there was a small project office which was set up in Bombay, consisting of exactly 2 people, and everything was done. Now, it is very, very important to note, and this I think is of crucial importance, that unlike the earlier leading case in Ishika Wajima's case, in this contract, there was no specific clause which laid down, as in Ishika Wajima, that the moment the goods, the capital goods were placed on board a vessel, there was a transfer of property in those goods, which took place outside India on the high seas itself. In fact, that clause was of great help to the SSC Nishika Wajima for the purpose of saying that the transaction was completed on the high seas, and therefore the profit which arose from that sale would never be taxed in India. We unfortunately did not have such a clause here, and therefore it was argued by the revenue represented by Mr. Venkatraman, and strongly and rightly, that this was a single inseverable contract for construction of the platform and also for bringing it here, and the title did not pass outside India, and therefore the whole of the profit arising from the contract was liable to be taxed in India, and all the more so because there was a project office. So we succeeded before the Supreme Court only on this ground, that the project office had only 2 employees, neither of whom had any technical qualifications. They had only the most basic commercial qualifications, and therefore they could only act as a communication channel. Therefore they had nothing whatever to do with the design, engineering, or fabrication of the platform, and that business could not therefore on this basis, our contention that the business of the entity, including in particular the business which consisted of designing and constructing that platform outside India, could not possibly be held to be carried out through that so-called PE in India. And that PE in India might be of some help only as a communication channel and for no other purpose whatsoever. This argument was accepted by the Supreme Court, and therefore, and so far as the profit or income which arose from the erection activity in India, it had already been offered to tax. We were really concerned only with the profit which arose from the activity of designing, fabricating, and engineering the platform, producing it outside India, and then that part of the transaction which accounted for the lion's share of the total income under the contract was held not to be taxable in India. Now, it is very important to note that, and that is the reason why I wanted to cite this judgment and deal with it. Samsung Heavy Industries refers with approval to an earlier judgment of the Supreme Court in Hyundai Heavy Industries. In Hyundai, they laid down a very important principle, I think the crucial importance of which we have not fully appreciated, and it is this. It says that no amount of income can be attributed to the PE in respect of the plant or machinery which is fabricated outside India, unless the revenue is in a position to show that the supply of the plant and machinery is not at arm's length, and the department makes an allegation and a case to that effect and makes it good. So unless the department is in a position to say, yes, the pricing of this equipment which is outside India is not at arm's length, they cannot attribute, even if there is a PE in India, they cannot attribute any part of the profit which arises from the engineering and production of the plant and equipment outside India to the so-called PE in India. I think this is a principle of crucial importance, because that burden which has been cast on the revenue to show that the pricing, the price at which the platform has been supplied to the Indian party is not at arm's length price, I think is a burden which is extremely difficult to discharge. There is another very interesting issue which was raised here. And since we are dealing with matters of international taxation, I think I'd rather spend a little more time on this rather than go to the next or third case. We put forward another argument that with regard to the true interpretation of Article 7 of the DTA, and the argument was this, that if the foreign enterprise itself made losses, then the question of attributing anything to the PE in India would not arise at all. We put forward that argument on the basis that a plain reading of Article 7 of the DTA said that the profits of the foreign enterprise will ordinarily be taxed only in the foreign country. However, if the foreign enterprise carries on business in India through a permanent establishment in India, then a slice or a part of that profit will be subjected to tax in India. So our contention was, the starting point of this whole attribution exercise was that the foreign enterprise makes profits. Only then the question of taking a slice of it and attributing it to the PE in India arises. If the foreign enterprise did not make a profit at all and it had a worldwide loss, then there is no question of taking a slice of that loss and attributing it to the PE in India, even assuming without conceding that there was a PE in India. Justice Rohinton Nariman found the point interesting, but he considered it prudent not to pronounce upon it. Therefore, the judgment is totally silent on this. But this is a point which is going to arise again and again and again in all those cases where the foreign enterprise shows that it has made losses and the revenue contends that it has a PE in India. And lastly, if I may take just two or three more minutes. The third case which I wanted to refer to and rely upon is the recent judgment of the Supreme Court in the case of Ramnath and Company versus CIT, which construes Section 80O of the Income Tax Act. And there the revenue succeeded. A very interesting case. The assessee was a pure vegetarian, but he was a worldwide renowned expert on Indian seafood. So he knew exactly what catches of seafood were made at each port in India, the quality and the quantity of the seafood catches. And he was regarded as an expert by buyers of Indian seafood all over the world. So he would give them information on what seafood catches would meet the requirements of each particular seafood consuming nation abroad, because he knew their tastes as well. Even though he was a strict vegetarian, and he told me that he had never tasted seafood ever in his life. And he got income by way of consultancy charges, which came to India in foreign exchange, and he rightly claimed the benefit of ATO on it, and the revenue denied that benefit. Now, we cited various judgments in which we pointed out ATO as it then stood was very widely worded. It said, even if you receive a payment in foreign exchange for information concerning industrial or commercial knowledge, skill or experience, that was covered by ATO. We cited one Supreme Court judgment, which I thought clinched the matter in my favor. But unfortunately, only when the judgment came, I knew it hadn't. It was a case of a reinsurance broker sitting in India who gave information to the reinsurance company sitting in UK and deducted his own commission out of the amount which was then remitted to the reinsurance company abroad. The Supreme Court held this was information regarding commercial knowledge and experience, and therefore, even though it did not come from abroad to India in the form of foreign exchange, and you deducted it from out of the remittance which was being made to the to the reinsurance company abroad, still you are entitled to ATO. So my submission to the Supreme Court was, we stand on a far higher pedestal than the case of the reinsurance broker. If he could get the benefit of ATO, how can I be denied that benefit? The Supreme Court held against us, and very surprisingly, it relied upon the judgment of the Constitution bench in Dilip Kumar's case. In Dilip Kumar's case, the Constitution bench of the Supreme Court laid down that where you are construing an exemption notification, then that exemption notification has to be construed with the utmost strictness. Why? Because you are relieving an assessee of his burden to tax, and as a result, other assessees are being made to pay more tax. Therefore, unless you construe it very strictly, justice will not be done. And if there are two views possible, then the benefit of the two views cannot go to the assessee. The benefit of the doubt or ambiguity must go to the revenue. They applied the judgment in Dilip Kumar's case to 80O of the Income Tax Act, completely forgetting that this is not a case of a mere exemption. It is a case of it is a case of a deduction, not an exemption. All the deductions under Chapter 6A, they have all been construed in the broadest and most magnanimous and liberal manner possible. We had given a whole list of judgments, but the Supreme Court proceeded on the footing that now that Dilip Kumar has come, all those judgments are overruled. In my respectful submission, that does not appear to be right for one very simple reason. A mere exemption stands on a different footing from an incentive provision which is given to assessees with the object and intent that the assessee will act on the incentive and take certain actions which ultimately will benefit the exchequer. For example, if we had exported and earned foreign exchange, country benefits, and therefore the benefit under 80O is given. 80HHC, if you make an export of goods, you get certain benefits. Certain other sections under Chapter 6A, you make an export of services or intangibles, you get the benefit. So where there is an incentive provision which is meant and intended to be acted upon by the assessee, then it cannot possibly be considered to be on the same footing as a mere exemption where without expecting the assessee to do something, you relieve a certain class of assessees from the burden to tax, and then the argument can be applied that you are exempting him and thereby you are coming down upon other assessees with a heavy hand, and therefore this assessee, this exemption must be construed very strictly. And this is apart from the basic point that the deductions under Chapter 6A, including 80O, they are not exemptions at all. They are deductions. There is a fundamental distinction in our income tax law between deductions and exemptions, which unfortunately the Supreme Court lost sight of. And here, Mr. Venkatraman may find the Union of India more than willing to file a review in the software case. I strongly recommended a review in Ramnath and Company's case, but my poor client was so disheartened by the result because he attended the hearing and he was convinced that we were going to succeed. And he had virtually had a celebration in advance. And when the result came, he was so shell-shocked. He said, I don't want to come anywhere near the Supreme Court again. Anyway, so I would end by only saying this. I'm reminded of an ancient Chinese blessing. The blessing is, may you live in troubled but interesting times, because that is what brings out the best in a human being. And I cannot help but to think that the Supreme Court continues to carry out and execute this blessing by giving us troubled but interesting times every single day of our legal lives. Thank you very much.
Thank you, sir. Great. So, Bala, shall I ask for PUC your concluding comments because we don't have much time for the questions.
I'm sorry if I consume more time than...
No.
No, if Mr. Venkatraman wants to respond for 3 minutes, we'll take that. Because there are some questions, sir, as to what are the next steps for the government. If if at all the government wants to consider, will there be retrospective amendment? Will there be changes in the Copyright Act? While I think the answers are very clear, probably from the government side, you can take that question as well, sir. If at all, probably it's a personal view, but what are the possible options?
I'll just give a 5 minutes alignment of our thoughts with what Mr. Ganesh. Of course, the 4 issues which he dealt, I don't want to be commenting today because it's not on software. As far as amendment or anything, I am at the moment clueless. As I said, these are my personal views, and I had no occasion to work with it with the government on this issue as on date. So nor do I want to jump the gun, because every decision in government, it happens in a style and in a measured way, and after a lot of thought process from, as it said, plurality is an art, is a virtue in any governmental functions. So I can't be representing all the plural thoughts in one forum to say this is what we are going to do. So let me not comment on that at the moment. Number one, I have only two points to submit in 5 minutes, in less than 5 minutes. See, working in government, I have understood the emotional appeal Mr. Ganesh made before the court and also before you, that OECD should substitute Income Tax Act, should substitute Supreme Court. All of us should stand up and say, what does OECD say? That should be the law. Then it's a very simple genre. You don't have complication at all. See the OECD, wake up in the morning, see what OECD says, follow it. But sovereign nations don't work that way. And how things happen in OECD, how a decision happens in OECD, it's something which when you work with government, you will understand it. So, and every nation has their own agenda to be protected. Every nation, and that is why I'm saying again, software, there is no uniform view, even amongst developed nations, even amongst developing nations. There is no one final view to say this is the world's view, and therefore to say you go by one view looks to be far-fetched. Two, so to say that OECD, in the absence of a contra view, certainly whatever judgments you have referred to will apply. But when there are reservations, when there are different plural views, to say you should only vote, I don't think Supreme Court has laid even that law in this software case, because the plurality of views have never been discussed in this judgment. Now coming to DTA, like any treaty, it is done with a lot of understanding, lot of gives and takes. But even though it is from a broader business perspective, ultimately it is a sovereign act and therefore tested in courts. And each country tries to defend its interest, its zone of taxation. See, if we are going to say it's a commercial document and therefore let us solve it commercially, there would not have been disputes at all. It's not that disputes are only peculiar to India. So all these are important as much as sovereign powers and decision making by judicial bodies are equally important. So how do you weigh? You will have to weigh the facts, you will have to weigh the circumstances, you will have to position yourself. Which criteria? There is no vanilla principle in DTA, there is no vanilla principle in OECD. That's my view after 9 months of working with the government. So we can't have one strong, this is how it should be. Put the lid and the whole problem gets solved. So now the last point, you were saying that several opportunities were given and India did not attempt to change. India is very consistent. It says that according to us, it is taxable both under DTA and also under the Income Tax Act. So where was the need for it to change? So it can't be saying we were consistent, we will also keep changing. We can't, the two wheels cannot go in opposite directions. So that will not take anyone anywhere. And of course, EULA, the assessee may have a case. Rest of the things, I think we will have to revisit it. How they are going to revisit, when, I do not know. I know Shekhar has already jumped with his team for the 2021-22 business plan of refunds. Shekhar, you'll have to wait. Let's see how it shapes in the future. It's a pleasure talking to all of you. I'm ready to take a few questions.
Before PVS gives a summary of the conclusion, while I do appreciate Mr. Venkatram sir, your perspective on that, but certainly on the software, on certain points, there is a consistent view globally, and there's a constant view globally on certain matters on software, be it Australia, be it US characterization, be it Spain, and some of the international judgments are consistent on that side, number one. Number two, on software characterization, as far as India is concerned, it cannot be taxed under the domestic, it cannot be taxed under the treaty law unless you bring the royalty includes computer software. With existing treaty law, you cannot bring it, whether it is a OECD or UN. Today, UN model developing nation also has got it, but there's a huge reservation even with the developing country, the UN model, whether software should be taxed as a royalty. So under the present circumstances, it is not possible. The only way the government can do that is that section 90 subsection 2 should be amended. Beneficial provisions of the treaty or domestic tax law should be amended. Taken out, bring a later in time principle like what we propose in direct tax code, and amend section 916 as royalty includes software. And again, amend Article 3 to definition terms not defined in the treaty law is subject to the context, which is a very far-fetched. So going by the present Supreme Court judgment, to my mind, it's very difficult for the government to amend the law. Of course, if the review petition comes, again, I'll go back to Mr. Ganesh asking me to support the review petition. Make sure the Supreme Court does not accept it. That's all I will do, sir. So thanks to you, sir. Sorry, PVS, back to you, PVS.
Yeah, I will take about 7-8 minutes. Bala, should be okay?
Yeah, absolutely.
Yeah, fine.
Please take it.
I may use the opportunity to give a story-like explanation of what has transpired today. See, my association with this software dispute, if I may call, goes back to the year 1997, when I was interviewed by Wipro for a job for the head of tax in Wipro. At that time, IT industry was new to me. I was from a manufacturing background, and the interview included Mr. Premji also. It lasted about 5 hours. One of the questions Mr. Premji asked, what is your view on software taxation? Obviously, it was important to his company, the company I was joining, but I had no clear thoughts as to where it will go. But be the question, I tended to give an answer to him. There's a very confused subject. It is going to be very litigious, but nevertheless, my gut feel is that it is not liable to tax based on my limited understanding of copyright law and a slightly better understanding of the income tax law. This is what I gave him. And as luck would have it, he had already got an opinion drafted by our legendary Palkiwala. The minutes were taken and he had kept it in his drawer and said, why don't you look at it and see whether it concurs with your view. So he had a view from Palkiwala at that point in time, which also possibly concluded the same way I had described. It is going to be very litigious, but nevertheless, it will not be copyright and it will not be subject to royalty. So there was some amount of convergence between the legendary Palkiwala and the novice P.V. Srinivasan at that point in time on a point of view on software taxation. The next interesting story was where after joining Wipro, I was flooded with all kinds of transactions involving software. So I could immediately see there was a reproduction, so it attracted royalty, there was no difficulty. There was a EULA where we were buying bundles of software from different foreign suppliers. We had to take a view. If I tell the foreign supplier this is liable to tax, he will say, fine, let us enter into net of tax liability and you bear the tax. Now again, it had to be a very difficult call. A lot of money is involved in the software imports, obviously. Then we were distributors also. We were very strong distributors of major foreign suppliers. So distribution segment also dominated our business. And lastly, there was also works contracts or customized software. Now you name it. I had the necessity to address all of them during my job, that you have to possibly take a position one way or the other and then go on with life. Certainly that was the second phase. Strangely, as soon as possible, as luck would have it, in the first assessment itself, the question about 40A1 came and the officer wanted to know whether the payment for software would be liable to a deduction of tax at source, and if there's a failure, why the expenditure should not be disallowed. I gave a very innocuous reply, half a page, maybe 1.5 pages, which I did not touch upon any of the decisions. All that I said is that it's like a book, it's like a CD you buy, and I also told him that sales tax is also paid on the transaction, essentially to say that it takes the character of goods. It was 1.5 pages of one which I gave. The officer, of course, did not agree entirely. He agreed that end use is certainly out of royalty, but distribution he wanted to possibly tax. And he took a view, not very informed view. Those were very initial days, and therefore that was the outcome. The Commissioner Appeals gave a relief, and it remained for quite some time. High Court also, Mr. Venkatraman happened to argue us on this matter early, and he virtually sustained the order of the Commissioner Appeals, saying that this is not royalty. Now, at that point, we already had the Samsung decision in Karnataka, which had already held that it is royalty. So we have two decisions from Karnataka, one saying it's royalty in the case of Samsung and Synopsys, another saying it's not royalty in the case of Wipro. This was certainly an eyesore for the department. They sooner or later had to touch upon it in somehow. So out of brute power, if I have to say, they touched upon it and said that's liable to withholding tax. And the climax came at a point when we almost restored it the same level as we had it in the earlier High Court orders. And we were engaging Mr. Ganesh for this at this point in time. So the two counsels who are now speaking so passionately on this subject, both of them have participated in the litigation with us, and both of them actually came to the same conclusion. But be that as may be, that the Supreme Court finally happened to deliver the final result even before we had to conclude on the software matter. And today we are in a position that we have a decision from the Supreme Court. In the interim, I was fortunate to be part of the Emerging Issues Task Force. As Shekhar rightly said, it was the second issue which was discussed. The first issue was issued, a clarification issued, and it was aligned to the Morgan Stanley decision which came later to say that if you pay the PE arm's length price, nothing else survives, and that a circular got issued, it got withdrawn, but nevertheless Supreme Court upheld that principle. So far also a detailed report was made. I would say the report which I read is as good as the Supreme Court order we are reading today, except that we had strong views from the government also on this. They are amazingly good. They brought forth points of view which possibly have not found place even in the Supreme Court order. So I would say that the same legal counsels who argued in the Emerging Issues Task Force, possibly a little more formidable opposition would have come for the assessees in the Supreme Court if you had consulted them, because they would have brought forth those points also to the fore. But anyway, possibly they are retired or not available to the government for providing insights of this kind, but they certainly had great views. But nevertheless, they appreciated the view which the overall committee members had brought forth. I will not reveal the outcome of the report for the only reason I am bound by the confidentiality which I had signed at the point in time. It will not be auguring well that I reveal the contents of the report which I am supposed to maintain confidentially. Now today, then the Supreme Court hearing of 6 days was, I was not fortunate to hear all the days. Bala, my colleague, was fortunate. He would report like Arunagiri, day by day, sentence by sentence, what happened in the Supreme Court. And we had some kind of a assimilation of what's transpiring in the Supreme Court. Again, we had some opportunity to assist Mr. Ganesh to provide what kind of decisions can be looked at. He gave us an opportunity, thanks to our some kind of a trust which we enjoy with him. We could provide some amount of inputs on a case where we don't have a direct nexus, but he was arguing for a client, and we could give some legal views to him, which possibly came of some use to him when he argued the cases. Then, after the Supreme Court, I never thought that we will be enjoying such a nice session on an order, which I thought covers every aspect of the copyright, every aspect of software taxation. Almost 50% of the order is dealing with copyright and how copyright should be interpreted. So that was really technical for a person who is only a tax person, but that is how the order is. The remaining 50% talks about other issues, if I have to say. So dominant discussion is on copyright, and copyright, possibly both the councils could have avoided a discussion on copyright and focused on commercial, what is that I'm finally paying for? If I'm paying for only use of a product, and copyright is incidental, fine, there may be some element of copyright. This is how I also looked at it as we started arguing. Today, Mr. Venkatraman really posed some very strong questions, which are a matter of, I wouldn't call it a matter of concern. At this point in time, I have no loyalties to anybody. I am as good a thinker as anybody else. I have got no vested interest to serve. So I will be neutral to any outcome. So I have got nothing to say. So I would say, when he essentially mentioned that the distribution alone is suspect in the entire decision, there is some merit to look at whether distribution is suspect. Of course, he himself would possibly concede that whether the right is exclusive or not would also be a very dominant element in that. If there is no exclusive right, possibly even distribution would not fall into the domain of copyright. Maybe that is the answer to the questions which may emerge out of it. Then the second one is whether the 2012 amendment is a clarificatory one, because the divergent views were already prevailing and the government had an obligation to clarify. It could have used any method to clarify. It chose the legal method to clarify, and therefore this was more in the nature of a clarification, and such a clarification should not be seen as retrospective, should not be seen as only prospective. It should be seen as a clarification in the light of an explanation which is already there in the Act, and it should be used as a aid to interpreting the law. I would have normally agreed with Mr. Venkatraman for the wholesome reason that yes, there was always a doubt right from the, as I even I recall, it was always a doubt whether it will fall which way. It was not very clear to anybody. Right from 97, I have been dealing with this issue. It is even from 92, the issue has been surviving in one way or the other. So I am very sure there were two views possible on that. But the government possibly chose only the wrong person for recovering the tax. The government should have possibly chosen the foreign suppliers themselves as assessees. Then the retrospectivity would have been got a little better handled. Even if the law is retrospective for a moment, it would not impact the assessee as much because a retrospective assessment of a assessee is possible. In a withholding tax scenario, a retrospective amendment has a different bearing altogether. An agency principle has to be looked at somewhat, and an agent will do as well as the government wants him to do, but it cannot do more than what the government wants him to do at that point in time. So if you look at that principle, you may find that if the government had rightly attacked the foreign suppliers, which it had done. For example, I do know many large foreign suppliers have been assessed directly by the government on their income, though they also attack the payers on TDS aspect. Maybe the government has collected double revenue on this at some point in time, one from the TDS aspect of it and one from the foreign supplier. Today it may not be possible because there is a Form 26 AS which gives the amount of credit to the foreign supplier. Earlier it was possible to have double collections also because there was no one-to-one correlation between the assessment of the assessee and the TDS which is done on the other hand. Particularly if it's a net of tax payment arrangement, the other party may not even know a particular TDS has been deducted or not. The Article 12 plurality has been talked about a little, so I will not. My own gut feel is that Mr. Ganesh talked about the formidable use of OECD commentaries, that they are actually commercial literature and should be used by businessmen for understanding commerce. I would have normally agreed with Mr. Ganesh overwhelmingly, with only one pinch of salt which I may add, that OECD commentaries are never consistent. There have been occasions with the same text of the articles, the commentaries are varied from time to time. So will you say that commentary would vary without the change in the text of the articles? This is a very nuanced point which the Supreme Court has not been put to any sharp question. If the Supreme Court is asked with the same commentary, if with the same text of an article, if two commentaries can emerge from the very same expert body, would you rely on the first expert commentary, or you will rely on the subsequent expert commentary? So we do not know. After some time, when Australia decides that it is copyright, when the OECD members will reverse the commentary to say, even this amounts to copyright, we do not know. The time may come that the OECD may revise its commentary, say that there's an element of copyright because Australia wants it to be a copyright at some point in time. So you have to see the OECD to be some kind of an organization which member countries we should be cautioned on those aspects a little more. I would possibly say it was a brilliant exposition by both parties. We had great amount of very nuanced points coming out from both the experts. They are possibly, when they are on the floor of the Supreme Court, we hear them the strongest. Even the outcome in the Supreme Court, the final outcome in the Supreme Court order, I can recollect the number of points which Mr. Ganesh argued and how many of them are finding place in the order. I think I can directly correlate that at most 60% of the weight of the order is a contribution which Mr. Ganesh has made to the entire argument. All these are coming out excellently well. I enjoyed the conversation. We certainly feel that the days of software litigation are not over. Certainly, there is going to be continued litigation. Even the form of import has changed. Today, we have software as a service. Whether the decision is any more important, given that software is a service and not software as a product, whether that would make a difference also we have to see. It's an emerging technology. Law will catch up with technology. Technology will outweigh law. So this is going to be the game we're on. It's an enjoyable ride. Let us keep on enhancing our knowledge. Possibly the lesson to learn is that businesses operate for commercial gains. So law should also apply in a commercial context rather than looking at it as a legal context. I can say raw material is deductible not because I understand it to be input which is used in production. I understand it as something which has gone finally into the consumption. I do not know the technicalities of production, but still I call it as raw material is deductible. Likewise, software constitutes royalty should be understood in a commercial context rather than a legal context. If a legal context is really intended, then the law should come very elaborately clear on that, so that there is no ability to decipher a different meaning for that. I will leave it at that level and leave it to Shekhar and Bala.
Thank you so much, PVS. I think that was a wonderful summary, and in the interest of time, I will keep my vote of thanks very short. Thanks to both the legal luminaries here, Mr. S. Ganesh, senior advocate, ably countered by Mr. N. Venkatraman, the Solicitor General of India. Thank you so much for your time here, sir, on a Friday evening, couple of hours being spent. We really enjoyed all the nuances that you presented before us. And as PVS pointed out, I think the litigation is not yet over. We will have nuances being debated a lot more in detail. We'll await some clarity in future. Thank you so much, and thanks to all the participants for patiently being with us and hearing our eminent speakers here. Thank you, and good night to all of you.
Bala sir, before we could conclude, Bala sir, since this is a virtual session, we would like to honor both the speakers a virtual memento. The mementos will reach to their office or home. Request Rupa to kindly share.
We'll do that. We'll do that. Wonderful. Thank you so
Bala,
much.
there's a national anthem. Is there, Bala? You have to
Yeah,
wait
after that,
sir.
Yeah,
Or
please.
2 minutes. Ganesh sir, we will make sure that are you having the national anthem, Prithvi?
Yes, sir. We have the national anthem. Request all of you to kindly stand for the national anthem.
शुभ नामे जागे, तव शुभ आशीष मांगे, गाहे तव जय गाथा, जन गण मंगलदायक जय हे भारत भाग्य विधाता, जय हे जय हे जय हे जय 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 हे.
Thank you.
Thank
Thank
you.
you.
Thank you to all
Thanks,
of you.
everyone.
Thank you, Mr. Ganesh sir. Thank you so much. And thanks, PVS. Thanks a lot.
Thank you.
Thank you for the participants. Thank you.
Thank you. Have a great evening and a
Thank you, sir.
great weekend.
Thank you, sir.
Thank you also.